Good morning, everyone. Thanks for coming back to another GAP class. This morning we have Bill Lindsey. He's with Gross & Welch in Omaha. He graduated from Creighton Law and the University of Florida with an LLM in tax. His practice emphasis is estate planning and probate, along with tax law and corporate and business law, including real estate. Thanks, Bill.
Good morning. Can everyone hear me? Okay. This is the Bridge the Gap Institute, and so I'm assuming most of you have either not practiced or not been practicing very long. Feel free to ask me questions. If it's here in this audience, I will repeat the questions for those who are on the webinar. When I first got out of law school, I have to admit, I didn't know a lot. I had all the book knowledge, but the practical side somewhat escaped me. Luckily, I started practicing law with my father, and so I had a mentor, and I got started with probates early because as a second-generation lawyer, a number of my father's clients were dying. So I was able to have that advantage of an experienced lawyer teach me the ropes. So hopefully I can help you along the way today. The first thing we need to figure out, though, is what is your role as an attorney? Remember, it's your client who's coming into the office. And the first thing to remember is they're not necessarily your client yet. They may think they are the moment they come in the office, but you always have the right to say no. If it's something beyond what you're capable of handling, don't take it. One of the rules in our office is don't dabble. Do something where you have no ability to handle it at all. So keep that in mind. But your role is often more a counselor at law. We've heard the old phrase, attorney and counselor at law. In this area, it's often counselor at law. You have to talk to your clients and know what it is that they're trying to accomplish. One of the things you'll find is they may be speaking a different language than you do. Your clients, if they're older people, didn't grow up with some of the things you grew up with. They don't have the knowledge of technology that you have. They don't have the experience of it. So keep that in mind. Take a look at history. And I found it fascinating throughout my career how history affected people. I was lucky enough in the early part of my career to deal with people who were adults in the Great Depression. Remember, Roosevelt closed the banks in 1933. People couldn't get access to their money. Think about that. Don't you think that would have a scarring effect on you? You couldn't get to the money? I found a large number of people who were in that era kept large bank account balances in their checking account at a time where savings actually paid some interest. So trying to get them to move it to the savings was difficult because they had that fear that the banks are going to close. So you have to deal with your clients the way they are. People who were children during the Great Depression were a little bit different. They often, scrimped on things because that's how they grew up. Now, most of you probably are not going to find adults in the Great Depression in your careers, since they're quite old right now. But you will find Korean War vets, Vietnam vets, and even baby boomers. I'm a baby boomer. Let me tell you something about the baby boomer generation. It's really two generations. It may sound strange to hear that, but I'm in the first of the two baby boomer generations. I'm in the group that was affected by Vietnam. Throughout high school, in the back of your mind was always, what's my draft number going to be? Am I going to be drafted? Am I going to be going to Vietnam? So I probably paid a little more attention to what was going on TV than some of my younger brothers and sisters would have. So the second half of the baby boomer generation wasn't as affected by Vietnam. That's just an example of what you have to find with people. Now, technology can affect someone. I've dealt with people who retired before Federal Express was founded in 1987. Faxes, they retired before that. They don't understand sometimes that the child that they may be picking to be their personal representative doesn't have to be physically in Omaha. When I first started practicing, that was something we seriously considered. Where is the person located? Not as much today with technology, with emails, the ability to scan and email a signature document back. It's not as much of an issue as it would be. You need to counsel the client to pick the right person. And most of the time when I deal with a married couple, I find that if I put them in separate rooms and say they have 3 children, and I would go in and ask each member of the couple separately with their children, which one would you pick to make a medical decision for you? They'll give me the same answer most of the time because they know their children. So keep all that in mind when you're talking about that. Also, make sure you set up something that the client can understand what you're saying. You have to read their body language, you have to read them, which is why it's very important to have in-person meetings with your clients. Over the phone, you lose a lot of communication capability. So in person, you can read things. You can look at them and see that they're not understanding. What is it about their background? Spend a little time chatting. A lot of times when I'm done, I put the pen down and we just do a little chatting at the end. And it's amazing how often I pull information out when they feel the pressure's off, because they're feeling pressure coming into you. They want to get this right. So you want to make sure that they understand. Now, remember what you're really doing is you're teaching. You're teaching them the rules so they can do their own estate plan. It's their estate plan. It's not your documents. If they don't understand something, you need to fix it so they do understand it. You need to be able to explain it to them. I had a client one time, and I just couldn't figure out why he wasn't understanding what it was that we were trying to put in the estate plan. He had some nieces and nephews, and he just didn't really figure it out until it dawned on me it wasn't any of the law that I was trying to explain. It was fractions. He had a hard time with fractions, but he understood a dollar, and he understood change. He just didn't realize he understood fractions, just I had to explain it to him in a way he wanted. So I took a piece of paper, drew a circle, drew it up into a pie chart, a pie, put each person's name, pulled out $1's worth of change, and said, out of every dollar, how much do you want each person to get? He did it right off the bat. So I taped the change to the sheet of paper and put it in the file, because later on he's likely to have the same question. Later on, we were reviewing the will. I pulled that back out. He remembered it. He said, yes, that's still what I want. So that was a visual demonstration to the client. So keep in mind that the client has to understand what you're talking about. Also, I know, for example, when I go into the grocery store, my wife laughs at me when I think certain things are too expensive, because I guess I'm used to a few years ago when they weren't quite as expensive. And so she laughs at me. Same thing happens to your clients. If they haven't been out in the business world, They don't understand what inflation has done. They may think certain things are, way high. They may not understand it. They also have emotional things to deal with. When you're dealing with somebody whose spouse has just died, they may not be ready to make a decision. When my mother my father died, and I would have some conversations with my mother. Sometimes the next day, she wouldn't not only not remember what we talked about, she may not have even remembered we had a conversation. So repetition is important. You need to make sure. And when you're done with the client conference, summarize what you've talked about. Put a summary together, particularly what the client has decided to do. Now, you may also have a client who has physical limitations. Recognize that. We were talking in the office the other day about a client who's totally mentally competent. This is an example. This isn't a particular client. But let's say they're a quadriplegic. They physically can't sign the will. The statutes in Nebraska permit a person, if it's in their presence, to direct somebody else to sign the will. So the will should reflect that fact and should state that. I've done a will for somebody who's blind. The will actually states that I read it to the person. The witness paragraph says that, and the affidavit says that. And I read it to the person in front of the witnesses. When you have a situation like this, the moment you're done, go back and do a memo to the file describing what happened. Someday when you've drafted a will, and when you practice long enough, eventually it's likely you will be a witness in court or in a deposition. So make sure you have the information available to deal with it. Now let's talk a little bit about the basics of probate. First off, the Nebraska statutes provide for what happens if you don't do a will. It's called intestate succession. Intestate means no will. Now the people who would receive, if there is no will, are those that you have to tell that there's going to be a will when you probate the will. Remember, probate is litigation. Effectively, you're cutting off the rights of the people who would receive if there is no will, so they have to be told about this. And from the beginning of your career, you need to make a distinction between two words, heir and devotee. And your clients will not make this distinction. It's up to you to do it. Heir is a person who receives if there is no will. Devotee is a person who receives under the will. So when I'm doing my application for informal probate, if a person is an heir, I say that. If they're also a devotee, I also say that. We're supposed to tell the court the status of the people involved. So keep that in mind. You need to explain to your clients the definition. I had an estate one time where I spent an entire afternoon tracking down and getting addresses for heirs just to send them a notice to say you're not going to inherit anything because there's a will. So I send them a copy of the will. I don't have any problems. I send out a copy of the will. When the client comes in, I think you should explain to them what happens if they have no will. So we have intestate statutes in Nebraska. Remember, that's Nebraska. If they have a farm over in Iowa, you've got to look at Iowa law for that. If there's a farm in Iowa, you've got to probate in Iowa, not just Nebraska. If you have a Nebraska resident, when you file a probate, that probate will be filed in the county in which they resided at the time of their death. That does not necessarily mean the county in which they died, but the county in which they resided. So keep that in mind. Whatever county they resided in is the correct venue. Nebraska's jurisdictional statutes in a probate also include territorial jurisdiction. There's a territorial jurisdiction. It applies to Nebraska, and it applies to intangible assets of people who were residents of Nebraska when they died. Now, with an intestate property, what people often don't realize is the spouse does not receive everything. What happens is, depends on who's alive. If there are any children alive, parents of the decedent don't get anything. You tend to go down. If there's a child alive, that child would be the sole heir if there is no surviving spouse. If the child is alive and is the child of the surviving spouse, the first $100,000 of probate assets goes to the surviving spouse. After that, it's 50-50. But we have three allowances: the family allowance, family maintenance allowance, the homestead allowance, and the exempt property allowance. These total $52,500. If you're looking at an older estate a few years ago, the number was changed. So it's now $52,500. And as one of our former probate judges in Douglas County told me one time, that has to come from somebody else's share. So effectively, what happens is the first $100,000 they get, then they get the $52,500 out of the next $105,000. That would be their half. Plus they get the allowances, $52,500. So it's $205,000 in that case. Above that, everything goes 50% to the child and 50% to the surviving spouse. What happens if that, say it's a stepchild instead of a child? So it's the decedent's child, but the surviving spouse's stepchild. There is no $100,000 number. It's a 50-50 split. So you start out basically the first $105,000, 52.5 plus 52.5, and then above that it's 50-50. Now remember though, not everything goes intestate. If you flipped, I think it's page 6 in your outlines. It's Roman numeral 7. It's a chart to determine who receives property at death. This is something I've developed to explain to clients who gets property at death. It took me a while to figure out how I actually do it, and so I developed this chart to explain it to people. There's 4 levels. There's ownership, contingent ownership, beneficiary, and then the estate, which means subject to probate. Clients often think if you have a will, there's no probate. That's not true. So looking at this chart, the first level is ownership. Ownership, the decedent had to own it in order for it to pass through the decedent's probate. If I were to leave Larry over here, the Woodman Tower in Omaha, in my will, Larry would not inherit it because I don't own it. That's how joint tenancy works. At the moment of death, the surviving joint tenant owns the estate, the asset that would be otherwise in the estate, and it passes to the surviving joint tenant by operation of law. So you had a deed between 2 people. They own a piece of real estate, joint tenants with right of survivorship. It goes to the surviving joint tenant. It's at level 1. It's also the level at which trusts work. Trusts work at level 1. So if you've transferred an asset to a trust, say you did a deed to that same piece of real estate and transferred it into the trust now owns it. The decedent does not. So it doesn't pass under the will. So what can happen is, and I've seen this many times, I'm sure you'll all run into it, the children of the first marriage come in to you and say, but Dad's will says we get everything after she dies. It says, no, Dad's will says you get everything if the spouse did not survive. The spouse survived, so the will is done. So keep that in mind. Now notice I used the word survived. That's technical. You can define what survival means in your will, and I do it in virtually every will. I define survival. I usually use 168 hours, which is 1 week. Why? Because it's simple. I can go down a calendar like this. It's now 9/22. If the person's alive at 9/22 a week from today, they now get it. If they die during that period of time, they don't. I had one situation where it was a 30-day survival clause, and the individual died 34 days later. So we had to open up a probate for the second individual to receive. So it's a guess. But the way I look at it is, if they're in the same car wreck and they survive a week, the odds are they're going to survive. That is a client-level decision. I tell them why. I let them decide. The two most common that I've seen are 1 week and 30 days. Under some federal tax law provisions, if you're dealing with a federal estate tax estate and it's a surviving spouse, you cannot exceed 6 months on that. Okay, looking back to the chart, joint tenancy. Now, one thing you have to do is make sure that the property is indeed joint tenancy. Look at the deed. See if it's a joint tenancy deed. I've had a number of circumstances where we ended up having to probate because they had a deed that was tenants in common, not joint tenants. If the deed says that it goes to a husband and a wife, but it does not use magic words like joint tenants, right of survivorship, it's tenants in common in Nebraska. That's not true in some other states, but that is tenants in common in Nebraska, meaning it goes according to the will of the first person to die. Okay. The second level is contingent ownership. College savings plans, 529 plans, were established by Internal Revenue Code Section 529. They're often called 529 plans. Nebraska has one. There's a Nebraska tax benefit. If you contribute to it, there's a small Nebraska income tax adjustment. It's not worth deciding that's where you want to invest. You have to decide, is it where you want to invest? But with a college savings plan, you have the owner of the plan, often called the participant, and you have the beneficiary. So if I set up a 529 plan for one of my children, I'm the participant or the owner. My child is not. My child is the beneficiary. Now, I can name somebody who's going to be the owner upon my death. So I name my wife as the owner upon my death. So if I die and my wife is alive, that college savings plan now belongs to my wife, and it's outside my will. No. Sorry, I thought somebody had a question there, so apparently I was wrong. Life insurance policies sometimes have successor owners. If I have a life insurance policy on someone else's life and I die, that policy doesn't pay off because that person didn't die, I did. So somebody now has to own that policy. Remember, life insurance policies have 4 people involved. You have the owner, you have the insured, you have the carrier, and you have the beneficiary. The owner and the insured do not have to be the same person. In fact, it's not unusual to have what's called a key man life insurance policy for somebody who is key to the operation of your business. So that there's some money paid so you can go find somebody who can now take over when that person dies. So successor owners. Now, I will tell you one thing about the 529 plan. There was a change a year or 2 ago that if you do not have a successor owner listed on the 529 plan, the participant becomes the owner. Now, the participant's underage, which is 19 in Nebraska, 18 in most states, that becomes a problem. You may need a conservatorship to deal with that. The third level is probably one of the most common, and that's the beneficiaries. We have beneficiaries. There's different types. There's POD, payable on death. You'll see that with bank accounts. TOD, transfer on death. You'll see that with securities. Brokerage accounts can have that. So you have to look and go over with the client when they come into your office. You have to understand this. I like to give them a chart like this quite often, or I'll do one by hand while I'm in there and giving them the explanation. Because they need to understand that the will doesn't cover everything. So one new thing that we have now is called a transfer on death deed. It's like a beneficiary in a life insurance policy. It's totally revocable. It was not unusual to have someone come in, their spouse has died, the child says you have to avoid probate. So they want you to do a deed in joint tenancy. That's often the biggest mistake you can make, because now it's subject to what goes on in their lives. What if that child owes child support? The moment their name goes on the title, the lien of child support attaches. They're in a car wreck. That's property owned by them. That can be sold. So be very careful. The key thing sometimes is to tell your client, well, we're trying to get what you want to. Don't necessarily fall for the mistake that they know what they want. They've heard from their neighbor, this is what they did. So you want to find out what is it they're trying to accomplish, not the particular technique that they're using. Finally, we get down to level 4, which is what's covered by the estate, and which is probate. Now, the estate cannot act by itself. The will is not self-activating. I've had a number of people go into the bank with the will, and the bank says, I can't do anything about that. You have to go through court. There is a common misunderstanding out there that probate is not required if you have a will. Technically, the meaning of probate is proving that the will is valid. In Nebraska, we have an informal probate process, and we have a formal probate process. Prior to 1977, we had an old probate code. So if you're looking at probate decisions before 1977, make sure that you know that we did not have the same probate code. So if you're looking to try to understand something, you have an old decision, you have to determine whether it still applies. January 1, 1977 is when that probate code came into play. That's just something to keep in mind. So you do the will, the client dies. One of the first things I like to do is have the family get together so I can explain things to them. Because this is like the military, it's a hurry up and wait situation. When we have the probate process, I usually open informally. A formal procedure requires filing a petition. We would file a petition. We have to publish notice once a week for 3 weeks in a legal newspaper. Get a hearing date set. Give notice out to everybody who might object. And then go to the hearing and get an order. Usually you'll get the order because most of the time people don't object. But if they do object, usually that isn't the hearing date. There'll be another hearing date set up for a trial. Yes?
Does notice need to be sent to known creditors?
Does notice need to be sent to known creditors? Not at that stage. the notice is sent to creditors after the appointment, because at that point there's a personal representative who might be able to pay. So that when a formal probate opening, there's 2 notices published. Before the hearing to tell people there's a hearing, and after the hearing to tell people that a personal representative has been appointed, and creditors the creditor's bar date, which is generally 2 months after the first publication. So a creditor can be barred, and we'll get to that in a moment. So we file this formal petition, you get the appointment. One of the questions you have to ask is there going to be a bond required? You in the will, when you're writing the will, can waive bond. The person making the will has that authority. The other choice is all the devisees, if you have a will, or if you're opening an estate where it's no will, it's intestate, all the heirs sign off saying there's no bond, then we can have no bond. If somebody feels that there's some problem here and there's already been an appointment with no bond, they can file a demand for bond. We can get a hearing set and see whether a bond is required. Now, you may think bonds are easy to get. They're not necessarily easy to get. I don't know how many of you have been involved in trying to get a bond, but it is not an easy thing to do. So make sure before you're going to be in a situation that a bond's required that your client can get it. Usually I send them to their property casualty insurance agent, particularly if they've been dealing with them for many years, because they'll go to bat for them if they want to keep them as customers. So you have to use practical reality on some of these things. So most of the time I find that the will waives bond. So we open the probate. And remember, I open informally. I file the application for informal probate, what's called a registrar statement. And the registrar statement is signed by the clerk magistrate, sometimes by the judge. And once that happens, letters of personal representative are issued. Those are your ticket to being able to collect assets. So once the letters of personal representative are issued, you get one free, and then they charge you. I think it's $1.25 for each certified copy after that. Most places want a certified copy. They at least want to see it. So I usually order at least 6 because I never know how many are going to be needed, and I'd rather have some. Now, there's a federal securities rule that says that those letters must be dated within the last 60 days. So if you're going to be in with a stock, a bond, a mutual fund, a brokerage account, make sure that you get to them as soon as you possibly can. Because if you do that, then you can go ahead and use those letters. Otherwise, you have to go back and order another copy. Now, here in Douglas County, they put the certification of the date that the copy was made on the back side. So for some reason, I found some people at some brokers don't make the effort to turn the page over. So if they tell you that it's dated the earlier date, because that's the date that's going to appear on the front side, you have to tell them to actually make the physical effort to turn it over. These are just some practical tips for you that I've had over the years. Okay, most estates are opened informally. Most of the time there's a waiver of bond. So now that informal registrar statement is the probate of the will. It can be set aside by a later formal proceeding, but the will has been probated. So the rest is actually administration of the estate. Within 90 days of the appointment, you need to file an itemized inventory. And the inventory includes more than probate property. Because we have Nebraska inheritance tax to deal with, we have the potential for an elective share to deal with. So items must appear on the inventory that would be involved in some of those things. Now, I think it was around page 27. No, let me go here. Okay, it's page 38. I hope your pages are numbered. Word sometimes does strange things to me. The purposes of the inventory, it's got several purposes. First, tell the court the property is subject to Nebraska inheritance tax. Second, list the non-probate property information needed to calculate the elective share. Third, list the non-probate property that can be brought back in if necessary to pay creditors. Fourth, the probate property, and to serve as a starting point for the accounting. You not only have to file the inventory, which is like a photograph taken on the date of death. People often look at that and think that's what they're going to get. I'm getting 25%, I'm going to get 1/4 of this. Well, the value has changed the next day. So it's just a starting point. You're going to have to track and see what happened. That's called the accounting. I like to use a checkbook register type of approach. We're all familiar with checkbook registers. The running balance, it goes down the account. And you do it separately for each account. And then show transfers between accounts. So when you close out the decedent's checking account into the estate account, you'll show the checking account and see it'll show what transactions occurred between date of death and the time you close the account out. Then you'll show that as a transfer into the account that you have open for the estate. I recommend opening a separate estate account. It makes accounting a lot easier. It supplies you with a lot of information for you or the CPA to prepare the income tax return, so I do recommend that. Now the inventory, and the value is the date of death, remember. Now how do you determine the date of death value of a mutual fund? Usually it's the ending value that you'll see reported. But if that's a Saturday, Sunday, or holiday, it's the average of the business day before and the business day after. If it's a stock, it's the average of the high and low on the date of death. If it's a privately held company, you may need to get an appraisal of that. If it's a farm, you may need to get an appraisal. Sometimes you rely on the assessed value, but remember, that's going to, whatever you use is going to be the basis or cost for income tax purposes in many cases when they later on sell the property. So keep that in mind. You are starting the work on somebody else's income tax return. If that farm later gets sold and you didn't go get an appraisal and it turns out the assessed value was low, you've given them a lot of money to pay tax on that you should not have done so. Also remember, farms are assessed at roughly 75% of farm value. If there's a greenbelt election on that farm, be very careful. If it's within development range of a city, be very careful, because farm values may not be sufficient. Now, I go through and I give you a listing of on what schedules you should be putting the items. We use schedules derived from the federal estate tax return, Form 706. That is available online at the IRS. The instructions are pretty good on this. They'll help you with valuation. Even though you're not filing a federal estate tax return, that is helpful to look at. I have based my set of instructions in here on that. Now, I've developed a way of figuring this so I can explain it to my staff on how to put things on the inventory. If there's a farm, let's take that as an example. Most people just go ahead because it's real estate, put it on Schedule A, which is real estate. But the first override rule is form of ownership overrides type of property. So if that farm is jointly held as joint tenants in right of survivorship, you now got form of ownership. That goes on Schedule E, which is joint tenants. If it's owned by a limited liability company, what you really own is the limited liability company, and those goes on either Schedule F or Schedule G, depending upon whether they have a beneficiary on them or not. A payable on death account goes on Schedule G. A joint bank account goes on Schedule E. So just keep those things in mind. A beneficiary designation or a successor owner also overrides type of property. So you have a brokerage account that would ordinarily go on Schedule B for stocks and bonds, but it is a TOD account going to your children. That now goes on Schedule G. It's a transfer during lifetime is what that is. It's basically because there was no other place to put it. I try to set up my inventories so Schedules A, real estate, B, stocks and bonds, C, mortgages, notes, and cash, and F, miscellaneous, are probate property. Everything else is non-probate. I like to put in the lower left-hand corner, just for the clerk, because the formal costs, if you do a formal proceeding, are based on the probate property only. I tell them the total probate property, the total non-probate property, and a total, and needs to match my inventory total. So now, how do you get the information to put on the inventory? Well, between you and your client, you need to figure that out. You need date of death values. So you have a bond. It pays interest. The next interest payment is October 15th. It paid April 15th, and now it'll pay October 15th. Most bonds pay interest every 6 months. Well, the bond is not just worth the dollar figure for the principal. There's also accrued interest from October 15th to August 12th. So we need that accrued interest. Generally, you list the bond, you give it a number, right underneath it you list accrued interest, and put that down. So you gather this information. I usually get at least the bank statement for the month involved and probably the next month in order to try to figure this out. Sometimes the bank will give you the information. You ask them for the accrued interest. Some banks, some of the bigger banks, will have to send it out of town to figure this out. Sometimes I just do it from having all the appropriate statements and just do the math. Brokerage companies can be helpful, but you need to make sure you tell them what they're supposed to do, because on stocks and bonds they'll also often give you the closing price, which is not the correct price. This inventory, remember, later on the client, the beneficiary's CPA, may be using that as their information to establish what the cost is or basis for income tax purposes. Okay, so now we go through, we file the inventory. We also have published notice to creditors. Once we publish notice to creditors, and usually the court does that, depending upon your county, you may have more than one paper. Now, in Douglas County, for example, we use the Daily Record, we use the Midlands Business Journal, or the Douglas County Gazette. In Sarpy County, there's Papillion, Gretna, and Bellevue that we use. Other counties you'd have to look at. But there may be a legal newspaper which is going to be far cheaper to publish in than the big paper in town. So research that. Check the statutory requirements. There's certain minimum circulations that are required. So you publish the notice, you're not done. You haven't told the creditors that they have a deadline date of 2 months after the first publication to file a claim. So you have to tell the creditors. It's unfair, basically, to do this and not tell the creditors. Plus, the statute says if you don't tell the creditors, they don't have 2 years. They have 2 months. They have 3 years. So you try to find all the creditors you can. You send them notice. If there was a good reason for not filing in the 2 months, upon a court order, they can file within the next 2 months. Now, it's not always done by filing a claim. They can sue the personal representative of the estate. An estate cannot be sued. You must sue a personal representative. An estate is not a legal entity. So since it's not a legal entity, you can't sue it. You sue the personal representative in their capacity as personal representative. So you'd sue William J. Lindsey, personal representative of the estate of whatever person. That's another way to do it. There may be a lawsuit pending. I had one case recently where there's a lawsuit pending at the time of death. You do a substitution of parties, naming the personal representative in that case, and they don't have to file a claim. Also remember, the IRS isn't subject to these rules because they're the federal government, and they're here to help you. Okay, now you get the creditors, they file their claims. You need to get a receipt filed from them when they're paid. They file a claim. You also want to check with your client to see your personal representative, who is your client, not the estate. Remember, it's not an entity. You represent the personal representative. So your client needs to determine whether that's a legitimate bill. If they don't believe it's correct, yes?
Can you clarify the representing the personal representative as the personal representative as compared to the $2 possibly affect this year?
Okay, that's a good point. The question is, with regard to the personal representative, you're representing them in that capacity, but they're also often the beneficiary of the estate. If you're representing them in that capacity as personal representative, and there's a problem that comes up among the beneficiaries, for example, if the surviving spouse files an elective share, your client's conflict passes on to you. I've recently been involved in a case where I represented the people as personal representative, and another attorney with another firm represented them individually. Actually, it's the other way around. I've got them individually. So this other attorney is representing them as personal representative. I couldn't do both because an elective share is really a dispute among the beneficiaries. The personal representative is neutral. Remember, with an elective share, you can override a disinheritance of a spouse. There's a statutory procedure for that. Okay, so we are continuing on. We look and see, is this bill legitimate? Somebody doesn't believe the bill is legitimate, we can file a notice of disallowance. And these forms are available in the Nebraska continuing legal education probate system. I think we're on system 5 now. I think it was 2 when I started. So those forms are available. You can check with the Bar Association to see about obtaining those forms. There is an electronic version, that does have some automation to it. So you send a notice of disallowance. That notice of disallowance says you have 60 days to file a petition for allowance or your claim is forever barred. That's an important thing to send. Now, I don't tend to send them unless there's a question about the debt. Some people routinely send them. That's up to you and your client to decide. What do you do? So they filed a petition for allowance. We're now in litigation. Discovery, interrogatories, depositions, all the stuff that you would do in litigation. If it's a very complicated case, there's a transfer procedure to go to district court if you want a jury. So there are things like that that can be done, with regard to that. If it's complicated enough, I've been known to ask for either a pretrial conference with the judge or the judge set out a progression order. So what you've heard about civil procedure to some extent applies in probate. All those things are available. People forget that. They think it's all administrative, and it is not. Okay, so now we've done this. We've made sure that the decedent's final income tax return is filed. The personal representative has that responsibility. They've collected this. The estate will have its own income tax return. We have to get a number for the estate. You cannot use the Social Security number of the decedent. You use Form SS4 to apply, and in my materials, you'll also find an authorization form. SS4 is on the IRS website. You can get the number electronically, but you have, in order for you to get it, rather than your client going online and getting it, you need authorization in writing, and I put a form in the materials at the end for that. Then we need to worry about closing the estate and making the distributions. So when we close the estate, we can close it formally, or we can close it informally. Again, most of mine are informal. I don't do formal unless there's a litigation reason, like the risk of litigation to my client down the line, because my client's the personal representative. If they're nervous about the situation, I will close formally so there's a final order and a discharge, which ends their liability as personal representative, absent fraud. And fraud does occur, you may have seen in the newspaper this week about some stealing going on under a power of attorney. That does happen. That has happened in probate estates. About 4 or 5 years ago, we had a big one in Douglas County where theft was occurring in a conservatorship. So you have to watch for that. Okay, you can close informally. You still need to account, which is that itemized listing of every single transaction in and out of the estate. You prepare a schedule of distribution that shows people how much they're getting. I like to show a calculation as to how I got there, because I'm trying to be transparent. I don't want to have to pull this file out 2 years later because somebody's been thinking about it and finally decides to ask me. I like to attach a spreadsheet that shows the calculations. Now, if it's pretty simple, like 2 people sharing 50-50, and they can see the bank account because I've given them the accounting, that's fine. Now, another possibility is if all people involved waive accounting, you don't need to file the formal accounting. And that doesn't mean you don't account between yourselves. It just means you don't file it with the court. I need the accounting for me or a CPA to prepare the income tax return for the estate because I need to see the deductions. Oftentimes the accounting tells me that they got some refunds that they didn't tell me about, so I may need to amend the inventory. Part of this whole process is doing the inheritance tax. The inheritance tax in Nebraska, there's 3 classes. 4, actually. I call it class 0 for a spouse or charity that are exempt from inheritance tax. Class 1 is children, lineal descendants, brothers and sisters. Spouses are the same, and relatives like stepchildren of your spouse. Class 2 is uncles and aunts, nieces and nephews, and their descendants. So you can go down on any of these classes with the exception of brothers and sisters. And then class 3 is everybody else. Class 1, the exemption per person is $40,000. The rate is 1%. Class 2, the exemption per person is $15,000. The rate is 13%. Class 3, the exemption is $10,000. The rate is 18%. This is paid to the county treasurer. It's imposed by the state. As part of the probate process, you file a petition for determination of inheritance tax. You'd have an inheritance tax worksheet. Most of the time what we do is we just get the county attorney to sign off on it so we don't have a formal hearing, because it's just usually a matter of numbers. You take them off the inventory, use the accounting to determine the deductions, you show an allocation among the beneficiaries, you prepare an order for the judge to sign, you file a petition. Now there's a legislative bill this year, LB 72, that will change some of the things with regard to trusts and inheritance tax. You will now be required after August 29th to notify the Department of Health and Human Services of the filing of an inheritance tax. This is the Medicaid department. If the person was 55 or older or was a resident of a facility that would be subject to the Medicaid rules. So if they were younger but were in a facility, you'd still have to notify. You do inheritance tax whether or not you have a probate. the inheritance tax becomes a lien on real estate. At 1 year, if you don't do it, there's a penalty of 5% per month up to 25%. The interest rate is 14%. And your personal representative has personal liability. Not a good thing to leave undone. And if you're trying to sell the house during the pendency of the probate, which is often the case, you need to make sure you do that, or the title company isn't going to issue you a title commitment or the title policy, and you won't be able to close on the real estate. So you file the closing. I usually file the informal closing. They remain the personal representative for a year. At the end, if there's no bond, nothing needs to be done. It's automatically terminated. Well, we're getting close to the end. I want to give people a chance to ask any questions you might have at this point. Does anyone have any questions? Yes?
I was wondering, how do you handle digital assets?
You raised a question that is really, the question was, how do you handle digital assets? You raised a question that is really in the forefront of the debate. I testified this year on the Uniform Fiduciary Access to Digital Assets Act that was introduced in Nebraska. The internet companies and the ACLU came out against it. There is federal law right now that says if you don't have permission, it is illegal to access it. Problem is, this federal law is written in 1986. You think it deals with 2015? I don't. But that needs to be dealt with at the federal level. There's a revised act that just came out last month that, in fact, the Real Estate Probate and Trust Law section will be looking at on Monday at our annual meeting to discuss legislation. And that's one thing we try to do in this area is to keep up on legislation. So right now, there's a law in Virginia that says you cannot get access to it unless you put permission in the will. So right now, I've rewritten my standard forms for wills to put this permission in there. But I also have a provision saying what accounts they don't have access to, because they're, for example, my work accounts, I'm not going to give my family access to that. That would violate my attorney-client privilege. So I would exclude that. I may have other accounts that I want to exclude from them. I authorize my personal representative to destroy certain information that may not be involved. Sometimes there's information that I've been given. I had one client who specifically told me not to ever give this information. So it wasn't needed for her estate. It's never been divulged to anybody. The same thing can be true of digital assets. The problem we get is the law in Virginia, which is they're trying to get in a number of other states, says you can tell them about the content. Not about the content, but basically the shell or the envelope. So it's really a big area. There's a lot of stuff out there. And American College of Trust and Estate Council had a task force looking at this. So it's really on the forefront of the law, so it's a very good question.
So what do you suggest to your clients to give out?
Right now, I suggest they make an inventory of their digital assets, and that we put provisions in the will and in the powers of attorney to say what happens, who has authority. And hopefully we're going to get past this federal law, because I specifically refer to the federal law and say, this is my consent under this law. Any other questions over here?
If an inheritance tax is owed, do you still have to file a request for determination?
Yes. But we have a separate order that we can use that says order determining no inheritance tax due. So I usually use that order if none is owed. And fill the worksheet out anyway, because that's what the county attorney expects to see. Any other questions over here?
I guess just to follow up on the digital assets,
Mm-hmm.
the language that you use, and are you getting specific, like this email account, this Facebook account, these photos that are in this account, how?
I don't get that specific, because just like with cars, those change. and so I try to generally deal with it. I may have to deal specifically with certain accounts, like business accounts. But remember, email. The photos on your iPhone are stored in the cloud. That's subject to the digital asset stuff. I can take one last question. Any others? Well, then I guess we get a little break until 10:15, then you have to put up with me again. So, thank you.
Hello, everyone. Thanks for joining us again. And now we've got Bill Lindsey, yet again, doing another hour for us on retirement plans and income taxes and how they fit into the estate plan and probate.
Now we get to the really fun part, income taxes. You're surprised that there's more than a few who would say that's the fun part. Income taxes are now the biggest component of estate planning over estate taxes. The federal estate tax and the federal gift tax in reality are one tax. They're opposed by different sections of the code, but the reality is they're one tax. And the reason that you need to know that is that you can make gifts during lifetime that use up some of the exemption that's available for the federal estate tax return. The exemption this year is $5,430,000 per person from federal estate tax. When you make a gift right now for a present gift, per person, the annual gift tax exclusion, now notice I'm using the word exclusion, is $14,000 per year. But what happens if you go over the $14,000? Assuming it's an unmarried person and they gave $114,000, they have to file a federal gift tax return. It is due April 15th of the year after the year in which the gift is made. And they have used up $114,000 minus the $14,000 annual exclusion, or $100,000. They made a $100,000 taxable gift. They've used up $100,000 of the exclusion, which means instead of $5,430,000, there's $5,330,000 left. That's the practical reality of it. That's not how it shows up on the tax returns. Because if there's an easy way and the hard way, the IRS generally does not choose the easy way. Now remember though, the number changes every year. 2 years ago, that number was $5,250,000. So since that number changes, you have to keep track of the taxable gifts and subtract them from whatever the current year's number is. The reason that's important is sometimes you'll come in, somebody has an estate of $4 million. If you didn't know that they'd made $2 million of taxable gifts, you wouldn't know that a federal estate tax return is due and likely federal estate tax is due. So keep that in mind. But most of your clients won't have estates north of $5 million. If they do, great. You have to do some more complex planning. So what comes into play is income tax. We used to always think about making lifetime gifts because of federal estate tax. Just a few years ago, the exemption was $1 million, and before that was at $600,000. So a $1.2 million combined estate between spouses was not unusual. 5.43 million times 2 is 10.86 million. Those aren't as common. So once the federal estate tax return, you look at it and you say, my client isn't going to have that problem unless they win the lottery, in which case they've got some more planning to do. But they're not going to win that. So now we look at it and they start thinking about making gifts. Well, if you make a gift of an asset that you bought for $1,000 that's worth $10,000, the beneficiary of that gift has the same basis or cost for tax purposes, $1,000. So if they sell it, they've got $9,000 of capital gains. Now, if they inherit that, and it's not in an annuity, not in a retirement plan or some other device that we'll get to in a few moments, they get a step up in basis. It's now $10,000 cost. They sell it, there's no capital gains tax. So we've kind of had estate planning turned on its head with the law that passed, I think it was the end of 2012 or 2013, right around there, that made the law permanent with regard to the $5 million estate tax exclusion. We were at $5 million, it was going to drop back to $1 million, so we really didn't know what to do in estate planning. So one of the things you may have to do in your careers is correct some of those things that were done at that time because nobody knew what was going to happen. Actually, the bill that was passed was actually passed in very early January of the following year. So it really got confusing trying to do those last-minute transfers, which I was doing between Christmas and New Year's that year, only to find out that I didn't have to do them in the first place. But Congress didn't tell us. So now, when you're doing this planning, you need to understand some basics of income tax. Basis is the most important concept as far as income tax that you need to come away with today. Basis, often called adjusted basis, because if it's a depreciable asset, every year you take depreciation, you reduce the basis by the amount of the depreciation. So it's important. Now, I find that sometimes, for example, if there's a farm that has equipment and buildings and fences, you need to allocate out the valuation to the buildings, to the fences, because those can be depreciated again. That does good for your client that's inheriting it. So basis is a concept. There's step up in basis, but that does not apply to everything. If it's inside an annuity, there is no step up in basis. It's what's called income in respect of a decedent. So no step up in basis on an annuity, no step up in basis on a retirement plan, such as an IRA, a 401k, a pension plan, any other retirement plan, no step up in basis. If they have a health savings account, there's no step up in basis on that. So anything where they didn't pay the tax because of some avoidance device, like a retirement plan or an annuity, they're still going to owe the tax after death. Somebody will have to pay that tax. The sole exception is assets owned by the decedent outside any of these special devices do get the step up in basis. So deathbed gifts are not a good thing. If you're below that, you may be depriving your client of some income tax benefits. So that's very important to remember that there's income tax benefits that can be involved. Now, when you're handling an estate, your client has the duty to file the final return or returns, depending on the time of year, of the person who died. Occasionally, you'll get somebody in who hasn't filed a return for several years. Make sure you don't have a flat fee on that case, so that you keep that in mind. But you have to make sure all the returns get filed. So making sure when you're doing the planning side that the people who are going to step in later on know where to find the returns, know who prepared them, so they can tell you, yes, the returns have been filed, and that person may be the best person to do the final return because they have the knowledge base You know, maybe they've been doing the returns for 20 years. So have them do them. But make sure that they're getting in all the special rules that apply as a result of death. Let's take two examples of special rules. Medical expenses paid after death, within 1 year of death, are deductible not on the estate's income tax return, but on the income tax return of the decedent for the year in which the services were rendered. So somebody who dies in August of this year, and in November you pay the final bill for the nursing home, even though it's paid by the estate, it can be deducted on the final income tax return. Oftentimes when somebody dies in a nursing home, you'll find that they have what I call deductions in search of income. They don't have enough income to use up the deductions. An example of how you can acquire more income to use up the deductions is an election you can make if they have savings bonds. Simple United States savings bonds. Generally, you'll see Series EE, Series I, or Series HH at this time. There may be a few of the single E's and H's still out there. But you have an right to elect on the return, the final return of the decedent, to tax all accrued savings bond interest. So if you do that, you now have additional income, and that savings bond interest would have been taxable to the beneficiary when they cashed the bond. So all of that interest then gets taxed on that return. You might be able to use the benefit of the lower brackets. So that's something to keep in mind if you have savings bonds. Now, there was until 2004 an ability to roll over old Series E or EE bonds into Series H bonds and not pay tax on the accrued interest. There's still some of those around. Those bonds have a 20-year maturity, so we still have a few around. So I always have a policy with any form of savings bonds. I want to photocopy the front of each bond. Each bond. Because they'll be stamped on the old Series HH bonds how much E-bond interest is taxable when it's cashed. You don't want a surprise. There's a program called Savings Bond Wizard that's available from the federal government that can calculate the accrued interest. It's a free program. I'd recommend it if you have a client that has this. You can enter all the information, get that all entered. You can have a nice sheet that you attach to the inventory, and it'll give you all the information you need. That's an example of where you can make an election that can help people because you end up not paying income taxes. Now, another thing when you're doing your pre-mortem planning before the death is take a look at the retirement plans. People often forget that deductions are important, that they can help you avoid paying income tax. A number of times in recent years, I've had people take out more than the required minimum from a retirement plan because I knew their parent or family member was in a nursing home, and at $7,000 a month, that adds up. That's $84,000 of medical expense deductions. So effectively, I can pull money out of retirement plans at zero income tax. So we calculate how much they can pull out. Or if we have savings bonds, we calculate how much to cash. Part of the secret to estate planning is there must be an estate to plan. So you need to make sure that you're doing the things proactively to make sure that that estate does exist. So those are income tax concerns. The estate will have its own income tax return. That's Form 1041. The beneficiaries may or may not pay tax. The estate may or may not pay tax. I like to think of an estate as one of the old-style corn bins, where you would load the corn in at the top, and down at the bottom there's a door. It's basically the law of gravity applying. I don't care what the legislature says, they can't repeal that law. the law of gravity. So if the corn is to stay in the bin at the end of the year, then the estate pays the tax. If you open the door and the corn comes out, the beneficiaries pay the tax on what portion comes out. It's an example that people can understand. And that's one of the things your job is, to explain things to your clients so they can understand it. So to the extent you make a distribution from an estate, it's considered to come from income. So there are exceptions, like if I give $10,000 to, one of my nephews, well, that's a specific bequest. There's no income involved in that. That goes out, doesn't take any income along with it. But if we make a partial distribution, that is considered to come from income first. Doesn't matter where it came from in reality. Remember, with the IRS, we sometimes go into Alice in Wonderland. We don't necessarily have everything the way you might think. So it comes from income first. So if you make a partial distribution, they may be getting a Schedule K-1, which is the summary form that says, this is your portion of the estate's income that you get to pay tax on. The estate gets a deduction for what it pays out. If it received $20,000 in income during the year, and it pays out $18,000 to two beneficiaries, they each have $9,000 of income, and the estate pays tax on $2,000. So keep that in mind when your clients are saying, oh, everybody's pushing for a partial distribution. Do you want to do it? You may need, if you're not going to do the taxes yourself, talk to the CPA and find out if this is going to be a problem. Get the income tax information. Now, as a practical matter, I generally won't let a client do a distribution during the time that there might be a claim. And I also make sure there's enough to pay the bills, because trying to get distributions back is not easy. Let me tell you, I've had to do that, and it isn't easy. Your client gets upset when they have to pay something from their own pocket. That's your job. Avoid that. Avoid your client having to pay from their own pocket. So now the estate files Form 1041. It uses an employer identification number, and it's very simple to tell from a Social Security number. There's one dash. Social Security numbers have two dashes. The dash in an employer ID number comes after the first two digits. You apply for it online. You use Form SS4. There's a limit now for what's called a responsible party, which is the person, say the personal representative. They can get one number a day. So if you've got a trust and an estate, and you need an ID number for each, you have to do it on 2 separate days if the person's the same person. Does it make any sense? No. Don't worry about it. Just get on with your practice. Okay, so now we apply for that number. On SS4, it says, what's the tax year end? You may think, tax years are calendar years. Not necessarily. An estate can select its own first tax year at the end of any calendar month that is 12 months or less from the date of death. Somebody dies today, they could select a tax year ending July 31, 2016 for that estate, or anything in between. So let's say for some reason I need 2 tax years. I'm trying to split things up into 2 tax years. So let's say a person dies today. Maybe I select November 30th of this year for the first tax year. Make whatever distributions I want to make to take income out. And then the second tax year starts December 1. Now, why might I do that? Because the 2015 forms will be available in February. The 2016 forms won't be available until February of the following year. So I use the form for the year in which it starts, but the person reports the income for the year in which it ends. So sometimes what I do is, say I have what is a big mistake, an IRA payable to an estate, which I don't do, and I will be very mad at any of you who do that. Don't do it, in other words. If it does happen, if it's payable to the estate, say the beneficiary has died and that's what the plan provides, well, I can actually spread that over 2 years by taking some by November 30th, closing my tax year, taking the balance in December, closing the estate at the end of February of next year. We're now in next year. So the second distribution is going to appear on the second return. That will be taxable to the beneficiaries in 2016. So I've spread it over 2 years, even though I've been 6 months. So those are some of the planning opportunities you have with income tax. So if you're not doing it yourself, you need to be working with somebody, your CPA or the estate CPA or whoever, to get some of this planning done. So I just point out that there are opportunities that you need to look at. Retirement plans are a big component of estate planning today. Other than houses, they're probably the largest wealth that many of your clients will have. And remember, generally speaking, they haven't paid income tax on that, and their family will. They haven't paid the income tax. Somebody will. With one exception. The beneficiary is a charity. So no income tax paid going in, no income tax going out. It's the best source of funds for charities, is retirement plans. So if they have charitable planning, quite often it doesn't appear in the will. It's in the beneficiary designation on the retirement plan. Because why should the family pay tax on that and get something out of there where you've already basically had a step up in basis in the estate when the family could avoid paying tax and the charity avoids paying tax on that IRA? So that's an example of tax planning. But let's get back to retirement plans. What are they? There are two types. Those that are taxable and those that aren't. You've heard of Roth IRAs. Roth IRAs, if they've been in existence for 5 years, are not taxable when they come out. Regular plans are taxable when they come out. There are penalties. Too early, too late, too much on all of these. If you put too much into a retirement plan, 6% penalty for every year it remains in the retirement plan. You take it out too early, 10% penalty. That's before age 59 and a half, unless you can establish disability. There are a whole load of other exceptions. I'm not going to try to go into those today, but there are. You need to look them up under your circumstances. Too late. If you're supposed to have taken a payment out and you don't, it's a 50% penalty. So clearly it's up to you to tell your clients, you need to get some money out by the end of this year if that's what the case is. And they need to know how much to take out. We have what are called required minimum distributions. When your client reaches age 70 and a half, they generally need to take those. Now there are a few exceptions. I'm not going to get into those today. 70 and a half. Remember what I said earlier about the easy way and the hard way? It would seem to me, it would have been easier just to say your 70th birthday. And it would make it pretty simple. But no, they chose age 70 and a half. And it's not technically due out to what's called the required beginning date, which is April 1 of the year after the year you turn 70 and a half. But if you take it out in that year, you then have to take out a second distribution by December 31 of that year. So generally I advise people to take out their first distribution the year they turn 70 and a half. Now there are tables that you use in calculating this. And while the person's still alive, You look at the table every single year and just pull the number out of the table. So while the person setting up the retirement plan is still alive, you pull it out. The number is a little bit over 27 if you turn 70 in the year you turn 70 and a half. So you would take 1 divided by the number in the table and multiply it by the balance the prior December 31, and that's the required minimum distribution. That's how much you must take out. With IRAs, it doesn't matter which plan you take them out of. With employer-based retirement plans, you have to take the minimum amount out of each plan. I generally try to take the minimum amount out of each plan just because it makes it easier for clients. They know they have to take this much out. Part of your estate planning can be dealing with retirement of your clients, and they need to know when they have to start taking these out. Now, what happens when the client dies? We talked about beneficiaries earlier. Generally, retirement plans don't pass through an estate. I don't like them to pass through the estate because if they go to the estate, they are probate assets subject to claims of creditors, which if you have an estate that is insolvent, that's effectively a 100% tax. So don't do that. Don't name the estate as a beneficiary. Make sure your clients have named beneficiaries. It's good practice to get a copy of each beneficiary designation and keep it in the file on that client. Because 10 years later, when they come in to revise their plan, they don't know who the beneficiary is. But always check to see if they've changed beneficiaries. They sometimes do. I had a client one time who called me up one morning, and she was very mad at her son, just extremely mad. None of you has probably ever experienced this with a parent, but sometimes they get mad at you. This one was to be the personal representative of the estate. I had the will on the computer. She said to me that she'd like to come in and change it. I could tell how upset she was, even over the phone. And I knew that she was so upset that we could have done it. She could have come in 15 minutes later, we'd have modified the will, and it had been changed. But you know what? That wasn't what she wanted. And she probably would have forgotten that she did it because she was so mad. When people are in a high emotional state, they often forget some of the things they do. And so something could have happened and found out something occurred that she didn't really want. So I said, I can't get to it till tomorrow afternoon. She called me up at the end of the day pretty sheepishly and said, I know what you did and thank you. So sometimes the best part of your job is not doing it at all. But that's to keep in mind. People will change things sometimes and then kind of forget about it. So double check, have them double check with the plan to make sure who the beneficiary is, or change all the beneficiaries again, even if they're the same one, then you know who they are. Coordinating beneficiaries with the will is crucial. You need to do that. Now, what happens when the person dies? First off, we still have required minimum distributions. This is where it gets a little confusing, so bear with me. We have what are called designated beneficiaries. Designated beneficiaries generally must be individuals. It must be human beings. Charities are not human beings and thus cannot be a designated beneficiary. So if you have a charity as a beneficiary, one entity or one person that is not a designated beneficiary poisons the entire plan. So if you have one person that's not a designated beneficiary, the plan does not have any, and we fall back to the rule that it must come out within the year of death and the 5 succeeding years, which is the base rule for no designated beneficiary. With a large plan, that can be a mistake because I may be able to stretch it out over a longer period of time. And there's two benefits. I get the benefit of lower brackets over a number of years. Second, while it's in the plan, it's still earning income tax free. So keep that in mind. Now, with the retirement plan, whether it be employer-based or IRA, you have a little bit of a grace that the IRS has allowed. They have a little bit of a grace period. The date on which we determine whether there's any people who are not designated beneficiaries is not the date of death. You can't add a beneficiary, but you can subtract beneficiaries after the death. For example, if charity was to get 10% of the IRA, if by September 30th of the year after the year in which death occurs, they've been paid out, they're no longer a beneficiary, everybody else was a designated beneficiary, you're okay. So that's one thing to keep in mind, that you can clear that up by September 30th of the following year. So if you can get them paid out, that's the way to go. Now I can deal with the other rules. Now what happens if the spouse is the beneficiary? If the spouse is the beneficiary, the spouse has an advantage that nobody else has. They can roll over the decedent's plan, whether it be employer-based or an IRA, into his or her own IRA. In other words, not pay any tax and not have to have the required minimum distributions because it's now in their own IRA and they're alive. So that's something that we often do. But remember, if it's in the surviving spouse's own IRA, that spouse is now subject to the too early rules. You have a couple, 55 and 54, they're in an auto wreck. One spouse dies. Survivor at 54 says, I'm going to roll everything over into my IRA. Oops. Now they can't take it out till they're 59 and a half because it's their own IRA. All the normal rules apply. So keep that in mind. Required minimum distributions, if you're before that required beginning date, which again was April 1 of the year after the year you hit 70 and a half, start with the year following death. So somebody dies in 2015, they must take the first payment out by the end of 2016. Failure to do so is subject to that 50% penalty tax. Plus, when you take it out, it's still subject to income tax. So it's a big mistake to not do that. Now, there may be some curative provisions, maybe some things you can do, but you're going to pay some fees to the IRS to get it done. So don't do it. Now, what happens, though, if the person was 70 and a half, and so they had their own required minimum distribution for the year in which they died? Their required minimum distribution, if they were otherwise required to take one, must come out that calendar year. So one of the things that I recommend is generally do not, I repeat this, do not try to take required minimum distributions in November or December of the calendar year. Because if you're doing that and your client dies before you get it done, we don't have much time to deal with a big company and try and get everything done by December 31. So I generally follow what I call the Halloween rule on this. All required minimum distributions out by Halloween. That gives me time. That's just a practical reality of dealing with this. If you don't know if it's come out, you better take one out, whatever the required minimum distribution was. Who does it go to? It does not go to the estate. It goes to the beneficiary. Now they'll have their own required minimum distributions the following year. Now that gets into a very complex subject on how you calculate those required minimum distributions. Depends on whether it's before or after the required beginning date for the death. And so I'm not going to get into too much of that. I'll do a little bit. There's a different table that you use. And you pick the age of the beneficiary on this other table for the year after the year of death. And let's say that number comes out to 15. So they have to take out 1/15 in that following year. I'm assuming that we're before the required beginning date. The next year you subtract 1. They have to take out 1/14 and 1/13 and so on. So if they have this, they can stretch that distribution out over 15 years, which certainly can be very helpful in their tax planning. They can't miss a year, but they can take it out over a period of time. This is called a stretch out. People ask you, well, I'm taking this stretch out distribution, can I take more? Absolutely. But the amount is based on how much is in there on December 31 of the prior year. So if you take more out, you're affecting how much you have to take out in later years. So they can do this. If it's a small amount, you're probably not going to do it. If they've taken the money out before they got to you, too bad, you can't put it back in. Now what happens though during the period of time between death and the time where they're competent? There may be a period of time where the person involved is not competent. They still have to take out the required minimum distributions. How do you do it? Sometimes they're set up to be automatically deposited on a certain date, in which case you're okay. But if not, have it in the power of attorney. Do a durable general power of attorney, and I put specific provisions in that allow them to withdraw from retirement plans. When in doubt, put a provision in. So a power of attorney can be a very valuable device in planning for that period of incapacity. And I think powers of attorney are needed even when you have a trust, because these retirement plans can't be transferred into a trust during lifetime. So have that power of attorney in place. Deal with the fact that your client may not be competent up until the moment of death. Somebody has to take care of things for them. We have sections 30-4001 and following are Nebraska's version of the Uniform Power of Attorney Act. That's something you should become familiar with. There's a form in there. You have to decide whether you like the form and are going to use it. But there is that form in there. And that's something that's part of your planning. There are certain things that you can't do under a power of attorney at all. A person with a power of attorney cannot make a will. My wife has my power of attorney. She can't make a will for me. Only I can do that. She can't vote for me in the primary elections next spring. Only I can vote for me. There's certain things that can be done only if you have the power in there. One is to change a beneficiary. I don't generally give that power to change beneficiaries. I provide that they can name a beneficiary. Say they've moved an IRA from one IRA to another, I provide they can name the same beneficiary, but that's as far as I'll generally go, because to me, that's changing the will. People think, when they think will, they're really thinking everything you do for the estate plan. You can't make a gift under a power of attorney unless it specifically authorizes the making of gifts. If you authorize the making of gifts, put some limits in on it. We just saw somebody making gifts that weren't appropriate in the paper this week. So keep that in mind. There are powers of attorney. You need to deal with that. Now, healthcare powers of attorney also are important to deal with that gap. Somebody to make a medical decision for you if you can't do so yourself. You can pick that person or persons. You have that capability. There's a shall format in the statutes that you can follow, which I generally tend to follow. But remember, this is someone making a medical decision for somebody else. They ought to know that they've been named. They ought to agree to have done it, to be the person. If they don't agree to do it, why would you want to name them? You just now have to have them sign off later on and go to the backup. And always name a backup, because this life is strange. So keep that in mind, that there's a healthcare power of attorney. You may have heard of a living will. The problem with living wills is there is no definition. So I ask my clients, when you say you want a living will, what do you mean by a living will? Best I can tell, the phrase living will came from Ann Landers or Dear Abby in the 80s. And I don't consider them to be some of the greatest legal minds of history. They may have been given good advice, but not necessarily good legal advice. So what they'll tell you will vary depending upon the client. But if what they mean is the advance directive, that basically says, if in the opinion of my attending physician, I am terminally ill or in a persistent vegetative state and death is imminent, stop medical treatment designed to keep me alive. Notice who you put that decision in their hands. That's the statutory format. You don't have to use the statute, but people tend to fall back on it. Said the attending physician. Who's the attending physician? Whatever doctor happens to be in charge of your treatment. So they're traveling somewhere. They're out in western Nebraska. They live in Omaha. Somebody who's in an emergency room in the western part of the state who has no knowledge of the individual, they can activate the living will. They tend to think it's their personal physician. It's not. It's the attending physician. So they don't know the doctor, they don't know the hospital, they don't know the diagnosis, they don't know the prognosis, they don't know the insurance coverage, and they're making a decision and putting it in the hands of the doctor. There's one person who can change that decision, the person who signed the living will, and they're not capable of doing that. Consider that when you're looking at it. Also remember, if you have a power of attorney for health care and a living will, which one controls? Technically, it'd be the later one in time. So you sign one 2 minutes after the other. Did you intend to override the other one? If you're going to use both, coordinate them. A lot of times, what I've seen when they're coordinated is it says, this living will applies only if there's nobody left in my power of attorney for health care to make a decision. If all you have is a living will, you've done a disservice to your client, because the only decision they deal with is death, not any decision prior to that. For example, they can't decide what nursing home because you didn't give them the power, which means you get to go to court to appoint a guardian. And there's no reason for that. You can deal with it ahead of time with the healthcare power of attorney. So I recommend that. Now, the final year of the estate can often be a short year because you may not have the estate open for an entire fiscal year. So you close it when you close it. Occasionally you'll get a letter from the IRS that says, like I just had this week, that says, well, why did you change tax years? Well, we didn't change tax years. We closed the estate. So even though you mark final return on the thing and you highlight it and you do whatever you can, the IRS doesn't always catch that. So make sure you mark final return on that. Make sure people know that they may be having something subject to income tax. Income tax is their obligation to pay personally. If they get a Schedule K-1, they get income tax on that. And they often don't understand that. So you need in your cover letter to them to say, well, we don't have the final numbers today, but part of that check is going to be subject to income tax. We think it's in this range, or don't tell them if you don't know, until the person who's doing the return can get it done and get the K-1s out. And sometimes, depending upon when the person died, like right now, I can't do a 2015 return for an estate. We don't have the forms. They're generally not going to be issued until very late in the year, if not the beginning of next year. And then I have to get my software to do the returns. So keep that in mind, that your final communication may be some months after you've closed the estate. And make sure that there's money in your trust account or the accountant's trust account to pay for the cost of preparing that return. Your client doesn't want to pay for that out of their own pocket. Okay, at this point I'm going to open it up to any questions. Are there any questions on any of this or the first session? Yes.
Earlier you were talking about the attending physician issue.
Yes.
What would your recommendation be to get, how would I word it to where it would give more power to selection of both?
Okay, the question was, how would I give more power, what wording would I use to selection of the attending physician? Well, the attending physician is selected by where you are, who's there, who has hospital privileges. You may not be able to select as the attending physician, but you don't have to use those words. You could say, if in the opinion of my personal doctor so-and-so, I meet these requirements. There's nothing that says you have to follow the statutory phrasing. So if you want to do that, that would be a way to do it. But remember, that doctor may not be available. So you have to have some sort of backup procedure for another person, or give somebody the authority to select the physician who's going to make that determination. Well, if you're going to do that, why not give them the power to make the decision? Give them a full power of attorney for health care. Then that way they can make any medical decision. I don't say to dismiss it. You've got somebody who has, say they're in a nursing home, they're 87 years old, they have no close relatives. Most of the variables are gone. Well, maybe you use a living will in that case. So that's, that's a matter of lawyering. You've got to apply we've got all sorts of tools. You have to apply them to the circumstances. You have to give your best judgment in suggesting to your clients, but it's the client's decision, not yours. Any other questions? Yes.
Regarding the IRA, you mentioned that you never make a trust beneficiary.
Now, I said never making that was a question of never make a trust a beneficiary. No, never make an estate a beneficiary. A trust can be a beneficiary. I did not get into those rules. They're fairly complicated. Before I would have you attempt to do something like that, you should talk it over with somebody, or at least read a good treatise on the subject, because the rules are complicated and they can result in that 5-year rule applying. The trust beneficiaries have to qualify as what are called designated beneficiaries. Sometimes I use what I call a conduit trust, which basically says the required minimum distribution comes out of the plan and immediately goes to the beneficiary. So you can do it. It's very complicated. Natalie Choate, C-H-O-A-T-E, has a book out, which is probably, in my opinion, the leading treatise on estate planning and retirement plans. She's in her 7th edition. I have that at my desk for my use because I can't keep all the rules straight. There's places that have available charts that show you how you calculate the required minimum distributions. I also keep one of those at my desk as a summary. So keep that in mind, that you can use a trust, but be very careful before you do it. It is a minefield if you don't do it right. The other thing about a trust is there's certain requirements that have to be delivered to the plan administrator by October 31 of the year after the year of death. If you don't meet those requirements, then your trust falls back to that 5-year rule. So you have to deliver certain things. The trust has to be irrevocable at death, a few other items like that. Okay, any other questions here? No other questions? I've explained it all? Or you're numb after all of this, one or the other? Well, I want to finish up with a couple of things. I have in my materials from the first session a chart that has the 4 levels. I find that to be a way to explain it to clients so that they can understand it. And you can tell them, oh, this isn't subject to will because it's on level 1. Or this isn't subject to will because it's on level 3. And having that in mind and using that at the conference with the clients to explain what's going to happen, it will be helpful, to that. Second thing is I've got materials on the inventory in there. Please look at those. The inventory, I see inventories with things on them sometimes where you have to go back through and try and figure out what's the probate estate. Because it has things on schedules that are probate because they're real estate rather than somewhere else because they're not a probate asset. So it can be hard to figure out. If you do a formal closing and the court miscalculates your closing costs because they don't know the probate estates, they're going to take the bottom line. You may have cost your client quite a few dollars just by not doing that. So it helps you keep it organized, and it helps particularly if there's something like an elective share that's filed. Now, when people sign someone else's name, it took me years to figure out the explanation that I use. But if I'm going to be signing my wife's name because of a power of attorney, I can't just sign Lisa Lindsey. That's called forgery. That's a felony. I'm not my wife. I would sign Lisa Lindsey by William Lindsey under durable general power of attorney. That's 3 components. The person whose name is being signed, the person who's doing the signing, and the legal authority. That in reality is what we do when we sign a document. It's just that when it's Bill Lindsey by Bill Lindsey under his own authority, we can drop the last 2 parts. But that's the reality of how you sign. So when I sign as a guardian for my ward, I would write her name by me, guardian. And that's important to get across to your clients, how they're signing. Works with corporations too. XYZ Corp by me, president. If I sign my own name, am I signing personally? You get into more complicated signatures. Okay, I have a corporation that is a manager of a limited partner, is a general partner of a limited partnership. So I would sign, XYZ Limited Partnership by ABC Corp, its limited partner by me as president of ABC. When I get complicated like that, I give my clients a standard signature block that they can then use and get a rubber stamp like you and I would remember from the old days. So keep that in mind. And then the last thing I want to remind you is retirement plans. You have to understand some income tax consequences. I'm not saying you have to do the returns, but you have to understand the income tax consequences in order, at least some basic level, in order to do proper planning. You need to make options available. The estate may not want to take advantage of the options that you presented it, but you want to preserve the options. A big part of estate planning is knowing you can't predict the future and preserving options for the people who will be dealing with it, who know the facts. They know all the variables. Let them make the final decision. So keep that in mind. Flexibility is crucial in estate planning. Final chance for questions. Thank you very much.